Online and distance contracts. Contracts performed at distance, those which are not entered into face-to-face, have become an increasingly important issue thanks to the ease with which one can shop online. However, they're not fundamentally new, as anyone who has any experience of mail order services will appreciate. Unlike a face-to-face transaction, a purchaser under a distance contract is unlikely to have the opportunity to examine goods which they are buying, and may be more limited in terms of the ability to ask questions of a vendor. As you will recall from previous podcasts, contract law does not generally recognise a right to reverse a bad bargain, or for a customer to obtain a refund for something simply because they do not like it, or it does not suit them. And while this is understandable, in the case of something which the consumer has had the opportunity of examining, it's much harder to reconcile with the concept of distance contracts, where the consumer is probably buying something sight unseen. Of course, some shops may choose to offer refunds or replacements on a voluntary basis as a form of customer service, but it does not really feel adequate to rely on this kind of goodwill or competition-based approach, rather than permitting expressly a right of return or replacement as a matter of legal right. The rules around distance contracts were, until recently, contained in the Distance Selling Regulations 2000. These have now been replaced with the Consumer Contracts, Information, Cancellation and Additional Charges Regulations of 2013. The 2013 regulations establish a good standard of protection for consumers when they buy from someone acting in the course of business. I would suggest taking a look through them, and I will highlight a few key areas here. Before a consumer is bound by a distance contract, the supplier must make information available to a consumer or give it to them directly in a clear and comprehensible manner. These duties are set out at Regulation 13. This includes to ensure that clearly and comprehensively the seller provides information about the main characteristics of the good, the identity of the seller and their geographic address, the total price of the goods and services, as well as additional information about delivery charges. There's a full list of the information that a seller needs to provide in Schedule 2 to the regulations. Where the distance contract is concluded by electronic means, certain information must be provided directly before the consumer places the order. Presumably, this means right before the user makes an offer to purchase or clicks a button on a website. See Regulation 14.2. Where a consumer has a right to cancel, and they have a lot of rights to cancel, a cancellation form must be provided, and there is a specified form for this. How do you deal with the situation in which the communications mechanism has very limited space? For example, business conducted by way of text message. The requirement to provide information in advance permits certain information to be provided in simply an appropriate way, which may include making it available on a web page to which the user has access. But some information must be supplied by means of communication by which the contract is concluded. Regulation 13.4a. This is still quite a lot of information, far too much for one text message, and so a vendor intent in using SMS as the way of contracting would either need to send a lot of messages or to simply conclude that contract by text message is no longer possible. Contracts can obviously be entered into online, and it must be very clear to the consumer exactly when they commit themselves to a contract. There are two requirements. First, the consumer must expressly acknowledge that the order implies an obligation to pay. This is set out in Regulation 14.3. Second, any button which binds a user to a contract must be clearly labelled Order with an Obligation to Pay, or a corresponding unambiguous formulation. This is a rather cumbersome form of words to use on a button, and I suspect that many sellers will choose Commit to Buy or simply Buy Now. If a seller does not comply with both of these requirements, the requirement that a consumer must explicitly acknowledge that the order implies an obligation to pay, and an unambiguous formulation when it comes to the ordering button, the consumer is not bound by the contract. Regulation 14.5. A supplier must give the consumer confirmation of a contract on a durable medium, including certain required information, within a reasonable time of the conclusion of the contract and always before delivery of goods or the commencement or the performance of any services. These rules are set out in Regulation 16. Durable medium is defined in Regulation 5 as including electronic form, which allows the information to be addressed personally to the recipient and allows the unchanged reproduction of the information stored. This would seem to preclude a link to a general web page on a supplier's site, since this could be updated at any point. Although, since a consumer could choose to save the web page or print it to PDF, you could argue not unreasonably that a general website satisfies the point. I suspect, however, we will need to wait for a court to rule on this particular issue, and my gut feeling is that simply including terms on a general website is unlikely to be sufficient. The burden of proof is on a trader to prove that if they did comply. So if a consumer complains that a supplier did not comply with the requirements, the supplier will need to adduce evidence to show that they did, and so will probably need to ensure that they keep records to be able to prove this. A consumer can cancel a distance contract at any time in the cancellation period without giving a reason and without incurring liability. Regulation 29. The default cancellation period is 14 days from the date of the contract, although where a seller does not correctly notify a consumer of their right to cancel, the right to cancel is extended to either 14 days from the date on which the seller provides the information, or, if the seller never provides the information, a year from the date on which the normal right to cancel would have expired. There are limitations on the right to cancel, such as a contract for the supply of goods which are made to a consumer's specification or which are clearly personalised, Regulation 28, as well as situations in which the consumer has lessened the value of the goods by doing something more than just checking that the goods work correctly and conform to specification, Regulations 29 and 34. Where a consumer cancels the contract, they must send the goods back within 14 days unless the seller has offered to collect them. Unless the seller has agreed to pay for the costs of return or has failed to provide information about costs, the consumer must pay for the return of the goods. And this is limited to the direct costs of return, and the seller isn't permitted to charge any form of restocking fee. See Regulation 35. The seller must reimburse all payments, except payments for special types of delivery, i.e. non-standard delivery types, and must do so within 14 days of the receipt of the returned goods or evidence of the return, or 14 days from the notice of cancellation in respect of services. The regulations also require that if a supplier operates a helpline for the purposes of consumers contacting the trader in relation to contracts, the cost to the consumer must be no more than basic rate, Regulation 41. Although it's not defined in the regulations, and frankly it's not a particularly helpful term, the government's guidance indicates that basic rate means a rate equivalent to standard geographic rates. In the UK this is for 01, 02 and 03 numbers, or for mobile rates, or the line must be free to call. You may be thinking at this point that the regulations provide a pretty comprehensive list of duties on suppliers in terms of their dealing with consumers. I think that's probably true, but it's worth bearing in mind that these do not exclude other duties. Other rules still apply. Existing requirements, such as those under the Electronic Commerce Regulations of 2002, which impose obligations on parties providing information society services, still bite, and suppliers will need to be aware of these. As you can tell, there really is quite a lot of protection afforded for contracts created at a distance, and in particular those by electronic means. This is a particularly relevant topic for me since, other than food, I seem to do most of my shopping online. Perhaps I have been fortunate in that, while I'm reasonably familiar with the various legal duties in relation to online contracts, I've not, yet at least, had to make use of any of the rights afforded to me. I suspect that as we see more and more business take place online, these rights are only going to get more important.